Right, good afternoon, everyone. I'm Nicholas Phillips. I joined Brick Court Chambers some 50 years ago. It was a bit different then. We had two silks. The head of chambers practiced criminal law on the Welsh circuit. We're running late. I've got 2 minutes to introduce the panel and their distinctions. I'm not going to. 2 minutes isn't nearly long enough. You can see who we all are up there. And if you want to learn about the panelists, it's all in the little booklet. So I'm just going to say one thing, which is that Richard and I were both pupils of Michael Mustell, and he loved competence, and what a pity it is that he's not here with us to enlighten us. So with that, and no more ado, over to our Jessie, who is going to introduce the topic. Okay. Sorry.
Thank you, Lord Phillips. It's my pleasure to introduce the topic today for panel 2, which is on the all-important, though quite technical subject of the procedural avenues for challenged jurisdiction under the Arbitration Act. As we've heard from panel 1, it is well established that competens, the power of an arbitral tribunal to rule in its own jurisdiction, is one of the cardinal principles of arbitration. This principle must be balanced with the orthodox position that a tribunal's decision on its own jurisdiction is always subject to review by the national court, the bootstraps principle. These two principles necessarily create a tension. If both arbitral tribunals and courts have the power to determine jurisdiction, when, how, and in what priority should these powers be exercised? This tension is particularly manifested in the 4 sections of the Arbitration Act that we'll discuss on the panel today, sections 9, 32, 67, and 72. These sections are extracted in your pamphlets, but by way of brief overview, for those who have not yet learned them by heart, under Section 9, the court must stay any court action brought in breach of an arbitration agreement unless satisfied that the arbitration agreement is null and void. Under Section 32, parties or the tribunal may, subject to stringent requirements, ask the court to determine the question of jurisdiction. And under Section 67, as we've heard from panel 1, awards may be challenged before a court for lack of jurisdiction. And under Section 72, a party who takes no part in the arbitration may ask the court to determine jurisdiction. We must also grapple with the case law on Section 9, which further provides that the court has a discretion in certain circumstances whether to refer the issue of jurisdiction to the arbitral tribunal or to decide it itself. As we can see, there are multiple procedural avenues in English law to challenge jurisdiction. Challenging jurisdiction thus very often becomes a strategic case management decision given to the recalcitrant party to decide how and when to challenge jurisdiction and before which body, a court or a tribunal. Today we have the benefit of hearing from this illustrious panel who will discuss the approaches in England, France, and Switzerland and consider the question of whether the approach under the Arbitration Act to procedural avenues for challenge of jurisdiction should be rationalised.
Good afternoon, everyone. I'm going to use PowerPoint slides so that you can see. So I'm not going to, as it were, read them out because you can read them for yourselves. I'm just going to try and summarize them. And I say straight away that this is a personal view, and I'm going to be a little bit iconoclastic too. That's probably because I was Nicholas's pupil, and he was always thinking about new ways of doing things. In fact, it was Nicholas who was Michael Mustell's pupil. I'm his grand-pupil on both sides, because I had another pupil master who was also Michael Mustell's pupil. So you might call that a bit of inbreeding, but I don't mind, because Michael was a very good person to be bred from. It's indeed a great pity he's not here, because I think he too would be iconoclastic. Right. What are we going to look at here? The question is whether or not there are too many ways in which the court can interfere with the issue of jurisdiction, with the principle of competens. Hence the two questions that I've set out there. So the ultimate question is, does the current statutory framework need simplification or clarification? Let's look, first of all, then, at how this might occur. There are at least 8 ways in which the substantive jurisdiction of the tribunal can be considered. Now, the first point to note is the fact that the Arbitration Act introduced for the first time into English law the principle of competens competens. It hadn't been in English law before then. And the second point is what Lord Justice Longmore said in the Court of Appeal in the well-known Fiona Trust case, which is what I've set out there. It must be right for the arbitration to be the first tribunal to consider, or arbitrators to consider whether they have jurisdiction to determine the dispute. So does the Act actually follow that? And I refer to the well-known book on the Arbitration Act by Merkin and Flannery, who point out the fact that there are these 8 ways in which this issue can be looked at by the court. I'm not going to consider 2 of them. I've identified them on the bottom bullet point, but we can move on to the next slide. So the first one is under Section 9. As you've already heard, this is the section in which a court can stay proceedings where it is said that there is an arbitration clause. Now, what does the court have to do, and what does the court have to decide before a stay will be granted? First of all, it has to decide, is there an arbitration agreement at all, and are the people in front of the court parties to it, and does it cover the dispute in question? Now, this does raise some very difficult questions of what is the standard of proof by which a party wanting a stay has to satisfy the court that there is a relevant arbitration agreement. And there are a number of cases on this, and I looked at them in some detail in this case called Aeroflot, Russian Airlines and Berezovsky, yes, that Berezovsky, in the Court of Appeal in 2013. And I came to the conclusion that it was something which was very difficult. In easy cases, of course, it's fine. The court can deal with it in a straightforward way. In more difficult cases, it means sometimes that the court has to decide, an issue has to be decided, it has to take evidence, might it have witnesses, and so on and so forth. Now, is this the right way for the courts to deal with that question in the context of a stay, where the whole object of the exercise is to get the matter to the arbitration tribunal? And should that decision of the court be final? But that's not the end of it. Even whatever the standard of proof is, that hurdle is got over by the applicant, the respondent can say, aha, even if there is an arbitration agreement, it's null and void, it's inoperative, it's incapable of being performed. So what is the standard of proof there? Now, the problem here is that it is based on Article 2.3 of the New York Convention, which talks about a stay not being granted unless the court finds that said agreement is null and void, inoperative, or incapable of being performed. What is meant by fines? Now, in Berezovsky, I said the standard of proof is balance of probabilities. So that would appear to be a final decision. Now, it is true to say that after Fiona Trust in the House of Lords, and the author of the leading speech in the House of Lords, if he's not here already, soon will be here. Oh, he is here. Good. Lenny Hoffman. He, of course, said, well, with Section 7 and so forth, the arbitration agreement is, as it were, separate and is pretty well inviolable. So the chances of there being no stay granted is going to be confined, I think, to a small number of situations. But given that we must have something like Section 9, 1 and 4, should the court be more ready to send disputed issues off to the tribunal, the arbitral tribunal, or not? And I point to the Mauritius International Arbitration Act 2008, which was amended in 2013, where the wording is different, where a party contends that there's an arbitration agreement, the court will transfer the matter to arbitration unless the other side shows on a prima facie basis that there is a very strong probability that the arbitration agreement is null and void, inoperative, incapable of being performed. So the thrust is that the court is only making provisional decisions and it's left to the arbitral tribunal to find out, thereby upholding the principle of competens competens. So that's a suggestion there for Section 9 to be altered. Second situation is Section 18 of the Act, which deals with the appointment of arbitrators. And of course, one reason not to appoint an arbitrator is for the party opposing to say, well, there isn't an arbitration agreement. Now, what again is the test that the court has to apply in order to appoint somebody? Good arguable case is probably the test. So if a court found definitively there was no arbitration agreement, then no appointment of the arbitrator. If the court satisfied to the good arguable case level that the arbitration agreement was existing, then presumably, if an appointment of an arbitrator was made, a party asserting there was no valid arbitration agreement could still challenge it before the arbitral tribunal, and that could again be challenged under Section 67, or if they didn't take any part in the arbitration proceedings, under Section 72. So if that is the right way to analyse Section 18, then it works in the sense that everything is left finally to the arbitral tribunal to decide, so there's no need to change Section 18. You may have different views, but that's my view at the moment. Now, we move on to the next one, the third one. Before the tribunal, you can challenge the issue of whether the tribunal has jurisdiction. Section 31 of the Act, based on the principle set out in Section 30 of competens competens. This challenge has to be made at an early stage, as you can see from Section 31.1. And Section 31.4 says that where an objection is taken to the tribunal's substantive jurisdiction and the tribunal has power to rule on its jurisdiction, because, of course, you can exclude it, then the tribunal may rule on the matter as to jurisdiction in an award on jurisdiction and deal with the objection in its award on the merits. So two ways of dealing with it. And this can give rise to some difficult issues. Interesting to note, and I think important to note, that Section 31.4 makes it clear that the parties can agree themselves on the particular procedure, and if they do, then the tribunal has to follow it. For example, if the party said, well, let's not have a separate hearing on jurisdiction, let's roll it all up together, have a proceeding which includes jurisdiction and the merits, and the tribunal can give an award on the merits. Now, as I read Section 31.4, that means that the arbitrators have to do it that way. However, in this Caltex case, Lord Phillips, my learned pupil master, stated that the tribunal can only deal with the jurisdictional objections in an award on the merits if it concludes that it has got jurisdiction. So, that means that if it decides it hasn't got jurisdiction, the award that it makes has to be only an award on jurisdiction. So, being very challenging, I'm going to respectfully ask, is that right? Is that the correct interpretation of Section 31.4? And what if the parties agreed, as I've just suggested, that they should do, everything on the merits? And I suggest that the very experienced arbitrator in Caltex, who decided to have one award where he held that one of the parties had not been a party to the contract. It wasn't a concluded contract, so he had no jurisdiction. And he also said the claims for breach of contract therefore failed on the merits, was the right way to do it and was in accordance with the Act. So, was the Court of Appeal's view on the construction of Section 31.4 in Caltex wrong? Should it be reversed by statute? Or should the wording of the section be made clearer? Those are the questions I ask. Now, Section 32 is the next one to consider. This is where the court can consider the issue of jurisdiction in certain very limited circumstances, which you can see in the second bullet point. Now, it also is clear that if the arbitral tribunal has been constituted, it can carry on and it can make an award. Presumably, it can make an award on jurisdiction if it acts quickly enough. Can that then be challenged under Section 67, or if one side's not taken part, under Section 72? Now, if the court decides the matter under Section 32, its decision is on a balance of probabilities. Presumably, it is therefore final, and you can't get any appeal to the Court of Appeal on that, except in very special circumstances. So I ask here, is this provision, Section 32, a very good idea? There's no equivalent in the model law. The DAC thought it should only be rarely invoked, and there are very few reported cases on it, and I've given you, I think, what is the latest case, a decision of Mr. Justice Tier. So the question I ask here for consideration is, do we actually need this section? Is it an unnecessary power given to the court when primacy should be given to the tribunal to decide jurisdiction? And I suggest, actually, it should go. Let's move on to Section 67. This you've already heard about quite a bit, and it was the section which was under consideration in that Caltex case, which I've already mentioned. Now, there was also an issue of fact in that case as to whether or not the parties had made an ad hoc agreement between themselves that the tribunal would decide on its jurisdiction. I said they had. The Court of Appeal disagreed. But we all agreed that if they had, then the consequence would be that if there was an application under Section 67 to challenge the jurisdiction, it would be bound to fail. And Lord Phillips said that in paragraph 50 of his judgment. Strictly speaking, I think it was obiter, but that was a clear statement. Now, in the Law Commission's interim report, it says in a footnote that Lord Phillips' Master of the Rolls is clearly wrong in that statement. Well, with great respect to the Law Commission is clearly wrong. Lord Phillips did not say, he didn't intend to say, nor did I, that what the parties had done was to try and oust Section 67, which they couldn't do because it's a mandatory section. What he said was, if they made an application under Section 67, it would fail. So Section 67 in force, Section 67 used, Section 67 producing the result that it would fail because there'd been an ad hoc agreement to jurisdiction. So I hope that that will be amended in the final version of the Law Commission's report. Now, just go back, because there is one, the penultimate bullet point I do want to press. Procedure. I add my voice to retaining a full hearing. It's too easy for self-serving arbitral tribunals to say, yes, there is jurisdiction. And what's the test going to be? Obviously wrong? Obviously wrong decision by the tribunal? That would cause injustice. So I say, keep Section 67 as it is, and confirm the obiter statement of the Court of Appeal in Caltex on the effect of an ad hoc agreement. Right, let's move on then to Section 72. This is a rather peculiar section which is operative when one party takes no part in the arbitral proceedings at all, and the court has the power to grant a declaration or an injunction or other appropriate relief in those circumstances on the issue of jurisdiction. And in the Law Depenture case, Mr. Justice Mann, wrongly called Mr. Justice Mance in the Lloyd's report, but it's just Justice Mann, considered the circumstances in which Section 72 could be invoked and reviewed other first instant cases. It was a rather special case because there was an option to have arbitration or court proceedings. But I come back to what Lord Justice Longmore said in Fiona Trust in the Court of Appeal. Despite the existence of Section 72, the court should, in the light of Section 1C of the 1996 Act, be very cautious about agreeing that its process should be so utilised. And he went further. If there's a valid arbitration agreement, proceedings should not be launched under Section 71(1)(a) at all. So I suggest that really Section 72 is not needed, and it really should be something that should be left to the tribunal and not to the court. Section 72 cases are very rare. I could find no recent ones at all. So I ask the question, is this really as vital as the DAC thought back before the Act was brought forward as a bill? I suggest Lord Justice Longmore's statement is sound, and Section 72 is not consistent with competens. So I suggest repeal it. And now on the last slide, I have made my conclusions. We need some clarification on Section 9(1) and 4, and I've suggested some wording off the top of my head, as it were. Section 31(4) needs some clarifications. Get rid of Section 32, get rid of Section 72, and keep Section 67 as it is, but admit that Lord Phillips got it right in Caltex on the question of ad hoc jurisdictions.
So good afternoon, and thank you for inviting me to speak today on this very interesting topic of compétence. I will focus, of course, on this principle, how it is applied in Switzerland, but just a few words to introduce the topic. I think what we have to keep in mind is that the rule of, or what we say the negative effect of competence, is actually a rule of priority. It's just that. It's nothing else. But it's, of course, a key rule of priority because it determines who decides first on an arbitral tribunal jurisdiction. That doesn't mean that only the tribunal decides, but it means who decides first. And if the negative effect of competence applies, it means that the arbitral tribunal will decide first. So if we consider that arbitration is a choice based on the parties' agreement, it's not a solution by default. It is, I think, of significant importance to let the tribunal decide first whether it has jurisdiction to decide a given dispute. Because without applying this principle, there may be, and we know all that, a great temptation for reluctant parties to try to derail the arbitration before it has even commenced, and thus by developing their case on jurisdiction. And we know how imaginative parties can be. So, in a sense, if the negative effect of competence is a rule of priority, as just mentioned, it is also, in my view, a question of logic and of coherence. And some may add it's also a measure of the trust and acceptance of arbitration. So if we now turn to the solution as it is implemented in Switzerland. I don't know, I had sent but then I will read them. I just sent the 3 articles which of the pillar which are relevant. But anyway, okay, then fine. Perfect. Perfect. So in Switzerland, it's very simple. You just have to refer to, actually, to understand the whole system, you just have to refer to 3 provisions, which are contained in the Private International Law Act. And I will start by Article 7. So Article 7 says that if the parties have entered into an arbitration agreement with respect to an arbitrable dispute, any Swiss court before which such dispute is brought shall decline jurisdiction unless A, the defendant has proceeded on the merits without reservation, B, the court finds that the arbitration agreement is null and void, inoperative or incapable of being performed, or C, the arbitral tribunal cannot be constituted for reasons that are clearly attributable to the defendant in the arbitration. Thus, Article 7 pillar doesn't mean anything. Article 7 of the Private International Law Act recognizes the negative effect of competence. This rule has been specified by Switzerland's highest court, i.e. the Swiss Federal Tribunal. And according to the Swiss Federal Tribunal's case law, the negative effect of competence apply in full if the arbitration clause provides for arbitration in Switzerland. The power of review of the court, in that case, is restricted to a summary examination. And this has been confirmed by the Swiss Federal Tribunal case law on various occasions. And notably, I mentioned one decision that's particularly clear in this respect. This is a decision that's been published in the ATF 122, page 139. The court actually says that if a Swiss state court is confronted with an arbitration defense and the arbitral tribunal has its seat in Switzerland, it will have to decline jurisdiction if a summary examination of the arbitration agreement does not allow it to determine that the agreement is invalid, inoperative, or incapable of being performed. And the reason underlying this rule is precisely the one I mentioned at the very beginning. And that rule is expressed by the Swiss Federal Tribunal in these words: you need to avoid turning Article 7 PILA into an instrument that can paralyze any arbitral procedure. So you have to limit the power of the court to review upfront an arbitration agreement, except in the 3 cases I mentioned, because otherwise it will deprive of effect the choice or the advantage that is given by the choice of the party to arbitration. So that is the principle or the negative effect of competence as it is viewed in Switzerland. But there is a big caveat, and I mention it very rapidly in passing. This rule applies only if the seat of the arbitration is in Switzerland. If the arbitration clause provides for arbitration elsewhere, the Swiss court's power of review is then unrestricted. So the reason supporting such a different approach is actually the following. If the seat of the arbitration is in Switzerland, at the end of the arbitration, there will be a possibility to ask for a setting aside of the award. And the Swiss Federal Tribunal will have the opportunity to review the arbitral tribunal's jurisdiction. Obviously, this possibility does not exist if the seat is abroad. Hence, the importance of giving the court, seized at the outset, the possibility to exercise a full review of the question of jurisdiction. So the idea, at some point, a court in Switzerland must have the possibility to review the issue of jurisdiction. If the arbitral tribunal is to sit in Switzerland, then that review can be done at the end. If it's not the case, so if the arbitration clause provides for a seat elsewhere, then there will be no review by a Swiss court, i.e. by the Swiss Federal Tribunal at the end of the proceedings. So the court that seized first has a larger power to review the issue of jurisdictions. So practitioners, scholars' position on this difference of treatment actually are very divergent in Switzerland. Personally, I doubt the distinction is really justified. And in my humble view, very humble like that of George Berman, the negative effect of competence should be applied in all cases. But one may understand the distinction, the difference. I'm not sure it is justified. But actually, here it's not a question of law. It's really a question, it's a political approach, how you consider the importance or not of being able to review as a jurisdiction, as a country, the issue of jurisdiction of arbitral tribunals. So we go beyond, to me, the question of a legal system and of the rule of law. It's a political approach of a given question that is decided this way or another. But in any case, I think there are two conclusions that we can draw from this review. First, the acknowledgement of the importance of arbitration to be respected and to thrive, to have a rule of priority, albeit in not all cases. This rule of priority imposes that courts decline jurisdiction unless narrow circumstances described in the law itself apply. And it also limits the power of review of the court when their jurisdiction is challenged on the ground that there is an arbitration agreement. And second, there shall be a possibility for a court to review the issue of jurisdiction. The application of the rule of priority goes hand in hand with the requirement that a court be granted the power to review the arbitral tribunal's jurisdiction at some point. In Switzerland, this review is exercised against the award, deciding on jurisdiction, be it a partial award or a final award. And it is exercised exclusively by the Swiss Federal Tribunal, as there is, as you know, only one degree of jurisdiction in setting aside proceedings. So let me turn rapidly to finish this presentation on the review by the Swiss Federal Tribunal of the arbitral tribunal's jurisdiction in setting aside proceedings. That's the second provision I refer to, maybe in the handout you have. International arbitration proceedings in Switzerland is governed by Chapter 12 of the Private International Law Act. And Article 186 of that Act provides that the arbitral tribunal decides on its own jurisdiction. That's what I mentioned before. A party who disputes the arbitral tribunal's jurisdiction shall challenge the award that is rendered, be it a partial award or final award, in which the tribunal has accepted, denied its jurisdiction before the Swiss Federal Tribunal. Article 186 provides, if you look at the last paragraph, that in principle the arbitral tribunal shall decide on its jurisdiction by a preliminary decision. As we all know, in practice, it is not as easy as that, and in many cases, issues of jurisdictions are intertwined with issues linked to the merits of the case, which lead tribunals to decide the issue of jurisdiction rather at the end of the arbitration with the award on the merit rather than separately, which is perfectly allowed according to Article 186, which sets a rule of, or a suggestion rather than anything that's mandatory for the parties. But that also explains why the parties then must have the possibility to challenge the decision, being the partial award on jurisdiction or a final award on their merit that will deal at the same time with the issue of jurisdiction if they deem it appropriate. So the appeal is limited to an appeal in setting aside proceedings before the Swiss Federal Tribunal. The question is then, what's the power of review? This is not exactly our topic, but I think it makes sense to consider it at the same time as we decide or we discuss the question of the priority rule. When the Swiss Federal Tribunal has to decide on an annulment proceedings on the ground that the tribunal will not have applied correctly the question of jurisdictions, i.e. had accepted or declined jurisdiction wrongly, the Swiss Federal Tribunal power review is full as regards the law. However, the Swiss Federal Tribunal does not review the fact unless specific circumstances are warranted. The facts are only reviewed in case of new facts, which the parties, which existed already at the time the award was rendered, but the parties could not know at the time without any mistake by them. They would have committed, having taken care about inquiring about the facts. They could not have known the fact. This fact can be reviewed by the Swiss Federal Tribunal. Or in the event that the issue concerning the award is precisely in the manner the facts have been presented. An example of that would be if let's assume a letter from one of the parties produced in the arbitration confirmed that this party has accepted jurisdiction of the tribunal. By an oversight, the arbitral tribunal just does not consider that document and decline with jurisdiction, then that's probably one of the rare cases in which the Swiss Federal Tribunal will review a factual question, because this is exactly the problem that led to the wrong decision on jurisdiction. So, with that, I think that concludes this presentation. So, to summarize in 2 words, rule of priority applies as regards jurisdiction if the arbitral tribunal is to sit in Switzerland. A court seized in first will have to decline jurisdiction based on a limited review, a prima facie review of the issue of jurisdiction. The question of jurisdiction will then be reviewed, if relevant, at the end of the arbitration or against a partial award that would be rendered on jurisdiction. If the arbitration is not to be seated in Switzerland, then the court seized first in Switzerland will have full power of review of the question of jurisdiction. Thank you very much.
Well, first I thank the organizers to have invited me to present one specific aspect of French law. What I've been invited to describe is the respective roles under French law of the arbitral tribunal on the one hand and the state courts, French courts, on the other hand, in assessing the jurisdiction of the arbitral tribunal. I will first give you a general idea of the French system and its logics. Then I will give you some indications on a few aspects of the sequence of events from the time that the party challenges the jurisdiction of the tribunal. And lastly, I will mention a very limited exception that has been introduced in the general system of French law. The French system can be summarized in 3 rules. First, the arbitral tribunal has competence. It has the power to decide whether it has jurisdiction over the case which has been brought before it. That's not particularly original. Second, and conversely, no party can seize a French court of the question whether the tribunal has jurisdiction over a certain dispute or potential dispute. There is no such possibility before the arbitral tribunal is seized or pending the arbitral proceedings either. And that is one aspect of the negative effect of the competence. Third, once an arbitral tribunal has taken a position as to its jurisdiction, whether positively or negatively, its award can be subject to an appeal before a court of appeal. If the court of appeal disagrees with the position taken by the tribunal's award will be set aside. In other words, the arbitral tribunal, as in Swiss law, has priority to rule over its jurisdiction, but the court, of course, has an important role, and its position is the one which will normally prevail. The rationale behind these rules is that it avoids losing time in protracted judicial proceedings before the proceedings on the merits can start before the arbitral tribunal. Judicial proceedings would take years because the normal proceedings in France have 3 steps. First, before the Tribunal de Commerce or the Tribunal Judiciaire, then appeal before the Court of Appeal, then pourvoi en cassation before the Cour de Cassation. So that's a huge lot of time that can be wasted if one prefers or allows parties to go to court before going to arbitration, or even pending arbitration. Now, the objection, of course, is that in certain circumstances, the result is very bad. Suppose the arbitral tribunal assumes its jurisdiction. Then it deals with the merits. Then there's an appeal before the Court of Appeal, and the Court of Appeal sets aside the award, either on jurisdiction or on the merits. Then the claimant only has to start again before a state court. At least in international arbitration, because the rule, as we'll see, is different in domestic arbitration and you lose a little less time. So the system is not always perfect. It depends on the situation. And what one may therefore hesitate. Is it preferable to have the issue of arbitral jurisdiction decided early on by a court, or to wait until the arbitral tribunal has decided the issue before offering the possibility of going to the Court of Appeal? I must say I have hesitated some time. But as a practical matter, even statistically, I would say that much more often than not, the assessment of the arbitral tribunal by the tribunal of its jurisdiction will not be overturned by the Court of Appeal. Because in most cases, if you have a certain legal problem, which is not always very complicated, why should 2 groups of persons, the members of the tribunal on the one hand, the members of the Court of Appeal on the other hand, have a different position? In my own experience as an arbitrator, either chairman or co-arbitrator, we have often decided issues of jurisdiction. There was never one that was set aside. Not because we're better than others, but because normally 2 groups of persons have the same position on the same problem. Also, I would say that very often there is not even an appeal. Very often there is not an appeal. So why give such importance to a situation which appears rarely? In the generality of cases, I would say that the French system saves time. There's another argument, I think, in favor of the French approach, which is that it's preferable not to offer to the respondent the tempting possibility of delaying the examination of the merits of the case by the arbitral tribunal. It's tempting for a respondent to bring to court the issue of jurisdiction, if that is open, because the respondent may hope that the arbitral tribunal will stay the proceedings out of caution, even if under the applicable law, like English law, for instance, the tribunal has the right to continue the proceedings, may continue the proceedings. But it's very uncomfortable for an arbitral tribunal, pending the examination of its jurisdiction by a court, to continue the proceedings on the merits and to make the parties spend huge sums of money to plead their case, only to learn at some point that it does not have jurisdiction because the court says so. So I consider that the priority given to the arbitral tribunal under Swiss law, under French law, is a good solution. Now, a few indications, necessarily brief, on the normal sequence of events, starting when the respondent challenges the jurisdiction of the arbitral tribunal before the arbitral tribunal. First point, there may be bifurcation of the issue of jurisdiction that may be agreed between the parties or that may be decided by the tribunal. In that case, the tribunal will render an award on jurisdiction, and that award can be immediately appealed before the Court of Appeal. Pending the appeal, the tribunal may stay the proceedings, but is not obliged to, and generally doesn't. Second, an appeal grounded on lack of jurisdiction of the arbitral tribunal can only be made by the party who had challenged the tribunal's jurisdiction before the tribunal, or by a party who did not participate in the proceedings, with the difficulty of defining the notion of non-participation, as mentioned by Hilary Heidbrun. 3, before the Court of Appeal, a party may invoke a new ground for lack of jurisdiction, provided he has challenged the jurisdiction before the arbitral tribunal. That is sometimes criticized, but that's the position of the Cour de Cassation. 4, the review by the Court of Appeal is made, I quote in French, translating from French, in the light of the factual and legal elements. And last point, if the court sets aside the award, so as I said earlier, if it's in international arbitration, the claimant has to start again at the lowest level. But if it's in domestic arbitration, then the Court of Appeal itself will decide the merits of the case. Now I'm coming to the limited exception to the priority of the arbitral tribunal to rule on its jurisdiction. This exception concerns the following situation. The claimant does not want to go to arbitration. He prefers to bring his claim before a French state court, and so he does. The respondent then objects to the court's jurisdiction and invokes the existence of the arbitration agreement, to which the claimant retorts, this agreement is null and void, or it is not applicable to my claim. Pursuant to Article 1448 of the Code of Civil Procedure, the court will retain its own jurisdiction only if the arbitration agreement is manifestly, the word is extremely important, is manifestly void or inapplicable to the claim. If it is not manifest, the court does not decide the validity or applicability of the arbitration agreement, and it declines jurisdiction to deal with the merits, which entails that the claimant must go to arbitration, with the paradoxical result that the claimant will go to arbitration first to try to persuade that the arbitral tribunal does not have jurisdiction on his own claim. So this is another aspect of the negative effect of competence. This exception, is very limited. It is extremely rare that the Court of Appeal finds that the alleged nullity or inapplicability is manifest. Almost never happens. There is one situation currently debated in which the Court should go beyond what is manifest. It is when the claimant contends that the arbitration agreement is incapable of being performed. You do not find these words in French law, but the situation exists. For instance, if the claimant is impecunious, so it cannot afford to pay the provision which is requested by the arbitrators for their fees or by the institution. If the arbitration agreement is truly incapable of being performed, sending back the claimant to arbitration will result in a denial of justice. So the word manifest here is not appropriate. You have to decide, the Court of Appeal has to decide whether, for instance, in my example, the claimant is or is not impecunious, even if that calls for a rather close examination of its situation. There are signs of an evolution in that direction in the recent case law. The Court of Appeal of Paris has rendered an award, a judgment, in which it seems that it would be ready to accept, to go beyond the notion of manifest. With this, I hope that I have given you a flavor of the French system, and I thank you for your attention. Thank you.